Hello friends and welcome back. So today we will discuss about non-compete clause in the business contracts and agreements, why it is used and the regulations around it globally and in India. A non-compete clause is a provision in an employment contract or business sale agreement where one party agrees not to enter into or start a similar profession or trade in competition against another party. And typically this clause is included in agreements between employers and employees, sellers and buyers of businesses or business partners. For example, a non-compete clause restricts one party, usually an employee, from competing with other party, usually the employer, after their employment ends. This can involve limitations on working for a competitor, starting a competing business, soliciting clients or employers, which means reaching out directly or indirectly, increasing networking and marketing efforts with clients or employees. The purpose of non-compete clause is to protect the confidential information. It prevents former employees from using sensitive information that gives them a business advantage, like trade secrets, business strategies, or customer lists, and that could harm the employer's business, right? Customer relationships, established connections that generate sales. This clause helps ensure that these relationships are not exploited by former employees who might try to lure customers away to a new employer or their own business, right? Competitive advantage, strategies or knowledge that makes business successful than its rivals. By restricting former employees from taking this insider knowledge to a competitor, non-compete clauses help to preserve the employer's superior position in the market. And business continuity ensures the stability of the business by preventing the immediate competition from someone who has a deep knowledge of the company's operation, right? What are the regulations around the world and in India? Non-compete enforceability differs across different geographies. Some places like California restrict them heavily, while other states in US like Florida enforce them strictly. In European Union, non-compete clauses are generally allowed but must be reasonable in terms of duration, geographic scope, and the nature of restrictions. And in some cases, employees must be compensated during the non-compete period. Similarly, in Australia, non-compete clauses are enforceable if they protect legitimate business interests. Regulations in India, so India's Contract Act restricts non-compete clauses to perform a person's ability to earn a living. So, as a general rule, non-compete clauses in employment contracts are void. Courts may enforce non-compete clauses in cases where they are reasonable and necessary to protect legitimate business interests, which include trade secrets, customer relationships, and sensitive business strategies. If they are limited in time, like 1 or 2 years, typically enforceable non-compete clauses have a duration of 1 to 2 years, although this can vary based on the jurisdiction and specific circumstances. And if they are limited in geography, the geographical scope of the restrictions should be relevant to the area where the employer operates and competes, right? So, in summary, non-compete agreements can be enforceable if they meet legal requirements, but their enforceability varies, right? Always seek legal guidance for precise advice on specific situations. So guys, this is all we have for today. You can go and watch video on indemnity clause in agreements which I have discussed in details. Please like and subscribe to our channel. Consider joining me on LinkedIn for regular updates. See you soon with another topic, another video. Till then, take care. Bye bye.